And now is the turn of my friend Nicolas Laferrière. He will be speaking about the teachings of John Paul II and the paradoxes of the right to life in the international human rights discourse. Nicolas is Director of Applied Legal Research at the Catholic University of Argentina, Faculty of Law, as well as Director of the journal Prudencia Juris. He's Director of the Center for Bioethics, Person and Family. He's Professor of Civil Law and Academic Secretary at the Catholic University of Argentina. He's the author of, or co-author of 13 books, 39 chapters of books, and 153 articles in journals on civil law and bioethical issues, and has lectured on topics of his specialty in all over Latin America and in several countries in Europe, in the United States, and in Qatar. Professor Laferrière.
Thank you, Alejandro. I'm deeply grateful to Ave Maria School of Law and Cardinal Stefan Wyszynski University for inviting me to participate in this Congress with such prestigious scholars from around the world. I especially thank Professor Ligia Castaldi and Monsignor Piotr Masukiewicz. Precisely in an age when the inviolable rights of the person are solemnly proclaimed and the value of life is publicly affirmed, the very right of life is being denied or trampled upon, especially at the more significant moments of existence, the moment of birth and the moment of death. Studying this contradiction denounced by John Paul II in his prophetic encyclical Evangelium Vitae will be the axis of my presentation. To this end, I will first propose 5 paradoxes of the regulation of the right to life in human rights law, especially in the international field. Next, I will offer an assessment of these paradoxes in the light of the magisterium of St. John Paul II. And I will end with 3 signs of hope and commitment at the beginning of the 21st century in relation to the protection of the right to life. Let's start with the paradoxes. In 1996, in a symposium in the Vatican entitled Evangelium Vitae and Law, Giuseppe Dalla Torre pointed out the ambiguous evolution of the legal experience in the relationship between life and law. So, while the legal protection of fundamental rights is broadened, the same protection is reduced through a splitting of the subject between individual and person. Taken as a reference the reflections of the Italian jurist, I would like to deepen what I consider to be some paradoxes that are verified today around the right to life in international human rights law. The first paradox involves the moment in which the legal protection of human being begins. Thus, although there are clear references in the Human Rights Treaty to the right to recognition of legal personality for all human beings, it is also true there are still positions that deny the character of a person to the conceived person, even though there is overwhelming evidence on the first moment in which the existence of the human being begins. The second paradox refers to a tendency to accommodate the beginning of life to biotechnological interests. This happened in the famous Warnock Report in 1980s in Great Britain, which, to facilitate the performance of in vitro fertilization techniques, pointed to day 14 after fertilization as a limit to cultivate human embryos in vitro. But in 2021, the International Society for Stem Cell Research issued new guidelines that extend that limit to day 28. so that embryos can be experimented on for a longer time. The third paradox. In 2012, the Inter-American Court of Human Rights introduced a new variant in the strategy to protect human embryos and facilitate in vitro fertilization techniques. Indeed, Article 4, Section 1 of the American Convention on Human Rights protects life from conception. This is unique of the inter-American systems. Life is protected in general from conception, explicitly in Article 4. Despite the clarity of the norm, the Inter-American Court held, quote, in my translation, that the conception in the sense of Article 4, Section 1 takes place from the moment in which the embryo implants itself in the uterus, which is why before this event, before implantation, no will give rise to the application of Article 4 of the Convention, end of quote. We see a flagrant manipulation of language, since it's evident that the word conception refers to the initial moment to fertilization, but it's changed in order to facilitate in vitro fertilization. Given that a person exists from conception and has the right to life, there should be no controversy, and the law should not admit attempts to deprive the unborn person of his life. But now, at the beginning of the 21st century, from the inter-American human rights systems, we can find pretensions to relativize the right to life. Indeed, even acknowledging that we are dealing with a person in the prenatal stage, yes, he's a person, all right, we agree on that. The Inter-American Court of Human Rights has said that the protection of the right to life in accordance with Article 4 is not absolute, and I start to quote with my translation, but it's gradual and incremental according to its development, because it does not constitute an absolute and unconditional duty, but implies understanding the origin of exceptions to a general rule. So, for the Inter-American Court of Human Rights, the right to life is not absolute when you are talking about the human unborn person. But the most radical way of altering the scope of the right to life is the attempt to justify abortion as a requirement of the right to life. This is what the Human Rights Committee has done in the General Comment number 36 on Article 6, Right to Life, of the International Convention on Civil and Political Rights. I quote, point number 8, a short part. States parties must provide safe, legal, and effective access to abortion where the life and health of a pregnant woman or girl is at risk, or carrying a pregnancy to term will cause the pregnant woman or girl substantial pain or suffering, most notably where the pregnancy is a result of rape or incest, or where the pregnancy is not viable. That's the Human Rights Committee in the general comment on the right to life. So this is the last paradox. This problem involves the end-of-life issues also, because the Human Rights Committee in this same general comment recognizes or tries to recognize the legitimacy of euthanasia based on the right to life. At the basis of these paradoxes is a controversy over the notion of human dignity, which has ceased to have an objective ontological foundation rooted in the excellence of being, and legislators, jurists, and judges that approve abortion euthanasia tend to identify human dignity exclusively with personal autonomy. Let's move on to the teachings of St. John Paul II on the right to life. Defending and promoting the right to life is one of the great axes of the magisterium of St. John Paul II. In this sense, it is impossible to summarize here all the richness of his teachings on this right. With this clarification, I will now refer to 6 aspects of his teachings that I consider particularly significant to address the paradoxes I have mentioned before. In the first place, St. John Paul II has deepened the relationship between natural law and human rights. a lot has been said about this. I won't go any further. This is a decisive issue to face the legal challenges posed by the paradoxes around the right to life. Secondly, St. John Paul II offers criteria to consider the problem in its international perspective. As he well pointed out in the Evangelium Vitae, quote, "One cannot overlook the network of complicity which reaches out to include international institutions, foundations, and associations which systematically campaign for the legalization and spread of abortion in the world." End of quotation. At this point, in the 21st century, and I think it's a new development that wasn't so clearly in 1995, we have seen a worsening of this problem, especially due to the growing power and influence exercised by international courts, which tend to force countries to reform their laws to legalize abortion and euthanasia. Thirdly, I highlight the clarity of the teachings of St. John Paul II to condemn voluntary abortion, Evangelium Vitae 62, and euthanasia, Evangelium Vitae 65. This clear condemnation has been a sure reference for all Catholics and for people of goodwill throughout the world, especially in the face of the complex legislative debates. And I connect this teaching with the next one. Fourthly, we must thank St. John Paul II, who, throughout his magisterium, offers timely distinctions regarding the right to life, which are decisive for these legislative debates. We can mention the distinction between direct abortion and the situations in which indirect abortion and an unwanted secondary effect is lawful. We must also highlight the precise distinctions between euthanasia and the decision to forgo so-called aggressive medical treatments. These distinctions have been vital for us in the public debates, and we thank John Paul II for this. Fifthly, I consider of decisive importance for public and legislative debates on the right to life the distinction between negative and positive precepts of natural law. This topic has been the subject of extraordinarily rich teachings by John Paul II, especially in the encyclical Veritatis Splendor. As far as the right to life is concerned, we must recognize that the negative precept that obliges not to kill does not allow exceptions, as explained in Veritatis Splendor 52. On the other hand, the positive aspect of the right to life invites us to search for new and creative ways of guaranteeing and promoting life, and there is a broadened field to create and to legislate. Sixthly, St. John Paul II contributed significantly to dimensioning the social projections of the threats to the right to life. That is to say, the problems of abortion, the elimination of human embryos, and euthanasia are not exclusively issues of individual morality, but have undoubted social consequences. Thanks to his teachings, issues related to the right to life have incorporated in the traditional social doctrine of the Church. Now I want to finish with signs of hope and commitment. In this context, in which there are great contradictions around the right to life, I want to present 3 signs of hope and commitment and try to show the connection they have with the teachings of St. John Paul II. In the first place, the advocacy to protect the rights of people with disabilities has emerged as a certain limit to biotechnological power. Aborting a person because of her disability is a serious form of discrimination and a violation of her right to life. The language itself, severe fetal malformations, already has a discriminatory charge. The eugenic use of abortion and euthanasia, but especially forced abortion, has meant that in countries which legalize abortion, up to 90% of people with disabilities, when detected prenatally, are eliminated after an adverse prenatal diagnosis. The Committee on the Rights of Persons with Disabilities has said, and I quote, laws which explicitly allow for abortion on grounds of impairment violate the Convention of the Rights of Persons with Disability. Even if the condition is considered fatal, there is still a decision made on the basis of impairment. Often, it cannot be said if an impairment is fatal. Experience shows that the assessments of impairment conditions are often false. Even if it is false, if it's not false, the assessment perpetuates notions of stereotyping disability as incompatible with a good life. The committee, end of quote. The committee has made similar recommendations to Spain, Austria, Hungary, and United Kingdom. I must admit that the Committee on the Rights of Persons with Disability has not recognized explicitly the right to life of the person with disability from conception and has a contradictory record on this issue. For instance, the committee has recommended Poland to ensure women with disabilities access for abortion. But overall, I think that we can see a sign of hope in the advocacy for the rights of persons with disability. In my own country, Argentina, the bill that sought to legalize abortion until 28 allowed abortion beyond the 14th week in the case of serious fetal malformations. Due to the opposition of groups of people with disabilities and the pro-life groups, this cause in the law was not included in the bill that finally was passed in 2020. This issue has been the subject of important interventions by John Paul II. As early as 1982, in his address to the First International Medical Congress of the Pro-Life Movement, he stopped to consider the moral issues involved in prenatal diagnosis and also in Evangelium Vitae 63. A second sign of hope is the emergence of a concern for vulnerable persons. In the beginning of human life, we can find a new and stronger commitment to vulnerable motherhood. In other words, abortion does not solve the problems that can influence the mother to make the dramatic decision to abort. Thus, there are growing efforts by jurists and policymakers to try to design public policies that address the cause of vulnerability in motherhood. Also, from the beginning of his pontificate, John Paul II assigned concern for mothers a principal place in his teachings on the right to life. Back in the general audience on January 3, 1979, in Evangelium Vitae number 90. And this is an urgent task that also Pope Francis has pointed out in Evangelium Gaudium. In the end of life, the law must promote palliative care as the adequate response to the problem of the vulnerable suffering person, as John Paul II proposed in Evangelium Vitae 65. A third and final sign of hope is the legal recognition of the right to conscientious objection. John Paul II was a strong defender and promoter of this right. His teachings lay the foundation for the growth in the number of objectors throughout the world, especially in health professionals. Regarding conscience, it is unavoidable to mention again the clarity and sharpness of the Encyclica Veritatis Splendor, which is intrinsically connected with the later encyclical Evangelium Vitae. John Paul II highlights conscientious objection as a duty. Además, in addition, St. John Paul II provides safe and clear criteria to discern complex moral situations, such as the one faced by legislatures in countries that debate laws on abortion. It is the famous passage from Evangelium Vitae 73 that has been so studied and so applied in these years. His teachings were also truly clear and guiding for the pro-life movement regarding the problem of cooperation with evil, for instance, in Germany with the problem of the pregnancy counseling centers and the state regulation of them in the abortion context. Faced with these paradoxes presented by the right to life in the context of human rights, the teachings of St. John Paul II remain current and are an unavoidable source for addressing these problems. I have tried to show 3 signs of hope linked with the limits to the existing tendency to legalize abortion and euthanasia. And I quote John Paul II, although laws are not the only means for protecting human life, nevertheless, they do play a very important and sometimes decisive role in influencing patterns of thought and behavior. End of quote. Therefore, it is particularly important to abrogate those laws that legalize abortion, euthanasia, and any violation of the right to life, but at the same time, it is important to work for a culture of life through legislation that promotes this right from conception to natural death. Thank you very much.